Welcome to Epstein Becker Green's webinar, Civil and Criminal Enforcement by the Department of Justice in the Trump Administration. Is it business as usual, or are there some new directions? We are pleased to have Epstein Becker Green's Stuart Gerson, Melissa Jampol, and Erica Sibley from our Healthcare and Life Sciences and Litigation and Business Disputes practices. Before we begin today's presentation, please be informed that today's webinar is being recorded and the participant phone lines will be placed on mute throughout the program. You are also welcome to submit questions directly to the presenters using the Q&A feature on today's webinar. In approximately 2 to 3 business days following the webinar, we will communicate the availability of the webinar recording and access to the PowerPoint materials. At this time, I'd like to turn the webinar over to Melissa.
Good afternoon, everybody. We are moving to the first slide here in our presentation, which has our agenda. I'm not going to run through it in detail. I think you can read it. But we're going to start with our first topic on upcoming changes to the Yates Memorandum, the risk to corporate executives, and re-examination of cooperation, credit, and fraud and other white-collar investigations. And I'm going to turn it over to my colleague, Stuart Gerson.
I'm going to start by speaking about the so-called Yates Memorandum. And the Yates Memorandum is named after Sally Yates, who was the Deputy Attorney General during the Obama administration. But the fact is that that's at least the 7th iteration of a memorandum concerning the Justice Department's commitment to seek individual accountability for corporate wrongdoing. I remember it starting as the Thornburg Memo, it was then the Terwilliger Memo, the McNulty Memo, the Thompson and Phillip Memo, and ultimately the Yates Memo. But the names are going to stop because the current deputy, Rod Rosenstein, informs me that he doesn't want to issue a memo with his name on it. He's going to approach this in a different way, and I'll come to that in a second. So what is this about? The Yates Memo incorporates guidelines for DOJ attorneys, both at Main Justice and in the United States Attorney's offices, considering the handling of investigations and prosecutions. And the idea is that since corporations act through individuals, that you can influence future behavior by prosecuting individuals who are culpable. What does that mean? How do you get to that? The concomitant of prosecuting individuals is gaining cooperation from corporations, and here lies the tension. And this is what we're going to talk about. This is where things are going. Why is there such an interest in individual accountability? Well, as a matter of policy, why prosecute corporations and let the bad guys go free? That's from the public policy standpoint of the Justice Department. And as I say, you can change behavior by influencing or scaring individuals to act well. So you need to get a deterrent feature going. These are the key points to understand. Although at the end of this, you'll be scratching your head and saying, now what do I do about this? But for a corporation, how do you get cooperation credit? How do you get especially if it's a criminal case, how do you get a deferred prosecution or a non-prosecution, or if there's going to be a prosecution, something that comes in a little lighter on the fine side? What do you have to do? Well, you know, because of the Yates Memo and all the ones that preceded it, that there's going to be a focus on individuals from the very start of a criminal investigation or a civil fraud investigation. You know at the end of it that there's not going to be a corporate resolution until the matter of individually culpable individuals is determined. What does that mean from the standpoint of those of you who are in corporations or who are defending corporations? It means that you need to make early decisions as to whether you're going to fight or flee. Many cases, especially in the False Claims Act area, settle. Companies want credit as quickly as possible. What happens as a result of that? That means that all too often there are individuals who are going to be thrown under the bus. It also means that there's the opportunity for more attorneys to be working on cases as conflicts of interest arise.
Well, so Stuart, in terms of your opinion, what does it exactly mean for a corporation to cooperate? Well, I think that that's an issue that's really come up within the leadership over at DOJ.
It comes up all the time, and the key issue with respect to cooperation, that is the moving part, is to what extent does a corporation have to waive attorney-client privilege in order to gain cooperation credit? That's the essential question that's asked, because in a fraud case, a corporation is expected to have conducted an internal investigation as part of this whole scenario. Okay, what gets turned over? The individuals who are interviewed in the course of such an investigation get upjohn warnings. They're told that these conversations are privileged, but the privilege is owned by the corporation, not the individual. The government comes along and says, all right, you want to cooperate, you got to tell us what everybody said. Well, oftentimes what everybody said involves trade secrets, sensitive business information, things that a corporation might not otherwise want to disclose. Does it have to do it? This question isn't answered, and I'll come to it again, but that's the fundamental issue. In terms of cooperation, there's a lot of easy stuff: making documents available, giving access to the government, answering the telephone when the government calls. The tough question is the one of privilege waiver.
Well, and I think we were discussing before we went live on the air that the issue of it depends on your individual prosecutor at DOJ or U.S. Attorney's Office as to what they view as cooperation.
Well,
do some people view answering the phone as cooperation, or other people don't?
Well, this varies. There is pretty decent consistency across the board within DOJ. Criminal division in the Department of Justice, civil frauds division in the civil division act in a fairly consistent and predictable way. If you're doing repeat business with those departments, so you have a pretty good idea of what's going to happen. There are people there who've been there for a long time. They become dependable. The problem is that the majority of cases, particularly in the criminal area, are not at Main Justice. They're in the U.S. Attorney's offices. There are U.S. Attorney's offices in every federal district, all across the country and beyond. And they act inconsistently. That is a key element of things that Rod Rosenstein, the Deputy Attorney General, wants to address. So when we look at white-collar enforcement under Attorney General Sessions, I think the first thing to keep in mind, and I'll say the same thing with regard to Foreign Corrupt Practices Act, with regard to antitrust, with regard to tax litigation, with regard to cybersecurity, it's business as usual. There are cases that vary from administration to administration, but I will tell you, based on my conversations with the Deputy Attorney General and my experience, I once was the Attorney General, things aren't going to change. And so what Rod Rosenstein is going to shoot for is a continuation of prosecuting individual wrongdoers for corporate misconduct, but to take the Yates Memorandum, refine it, make it clearer, more concise, improve training, and gain consistency across the country. It's a noble aspiration. And these are the things, as you can see on the slide, that the Department of Justice is currently doing: ramping up training, establishing working groups, conducting some pilot projects in the foreign corrupt practices areas is one of those areas. And then what has constituted the Yates Memorandum is anticipated to be republished not as a memorandum, but as a new section in the U.S. Attorney's Manual. Why is that important? Well, the U.S. Attorney's Manual is a regulation that has the force of law. It's the resource that you can find it on the web. There's no great secret to what's in it, but this is the policy under which assistant U.S. attorneys will be held responsible. It gives clear notice, better notice, by putting it into the manual along with everything else that's in there about what a company needs to know and to plan and prepare for the early decisions that it has to make. It's in there along with some other things that have become increasingly bothersome to actual and potential defendants in criminal cases, like, for example, the compliance of various U.S. attorneys' offices and sometimes Main Justice with responsibilities under Brady against Maryland and other matters involving disclosure, where there have been some very unfortunate recent cases where U.S. attorneys and people at Main Justice have been taken to task. So that's the direction that we're going in. The next couple of slides reiterate the same sorts of things, other statements that Deputy AG Rod Rosenstein has made. You have a question, Melissa?
I do for you, Stuart. My question is, what do you view about the Deputy Attorney General's emphasis on people sort of self-policing and self-reporting?
Well, we'll come back to that again in the Foreign Corrupt Practices Act area, where that seems to be working. The idea of gaining cooperation credit in part has to do with voluntary disclosure and self-reporting. Erica may want to talk a little bit about that when she speaks about the Department of Health and Human Services Office of Inspector General, which has a voluntary disclosure program and encourages it. And of course, the OIG works in tandem with the Civil Division, the fraud section of the Civil Division of the Department of Justice. So that's an apt question, and that's, I hope, an apt answer. Going forward, what is it that a company needs to think about? Well, given the fact that you need to make an early decision if you're a company about cooperation and whether you have a settlement strategy, and so you're seeking cooperation credit, you've got to decide who you represent. Are executives who are targets, who are not going to be part of any settlement, within the scope of your representation when you're seeking cooperation credit? Well, that becomes very controversial. You get into the issue here of joint defense and common interest agreements. But if you're in a position to control the assertion of privilege by an individual, that puts you in a potentially compromised position with respect to cooperation. So it becomes increasingly more difficult to have the same attorney represent both a corporation through its board and at the same time management, if management is a target, if it's clear that there's a division of view, or at least a potential division of view. That's the most difficult question that you deal with on the threshold. Who is your client, and how do you react to it? And where you have separate counsel, where you decide that that's the way you're going to go, the extent to which the two wings of your defense, the company and its individuals, management, can cooperate with each other. So you need to keep that. You need to keep that in mind. So the takeaways are right there in front of you. I've just mentioned what the immediate issues are. At the bottom, before I pass the ball back, let's note, as we always do in these things, that the best practice here is to attempt to avoid having these problems to begin with. Having a strong internal compliance program, having compliance people who can report periodically to the audit committee or compliance committee of the board, having a management that's sensitive to ethical training. These are very important, and they're important for another reason. I mean, avoiding cases is one thing, but under the sentencing guidelines, the corporate sentencing guidelines, you get substantial credit, exponentially substantial credit for having adequate compliance programs, even if you're going to have some miscreant activity along the way. Okay, that's enough for now, although you want to ask a question?
Yeah, so I'm interested in your thoughts on this, because you come at it more from a civil angle, and I come at it more from my years as an AUSA on handling criminal matters, is that the Yates Memorandum, or this issue of cooperation credit or targeting of individuals, sort of all the topics that we're talking about here in this first segment of our presentation, didn't really affect criminal prosecutions nearly as much as it has resulted in a sea change in the civil world. That's sort of my take on it.
And I'm wondering, can I disagree with that?
Of course,
first
yes.
I do a lot of criminal cases, and I was a federal prosecutor. So, but no, I don't think that that's true. I think that we've reached kind of a stasis where the same criteria apply to cooperation and prosecution of individuals, both in criminal fraud and civil fraud cases. I really don't see any difference. The real problem here is where there's leveraging, and you unfortunately see this in all too many U.S. attorneys' offices, where there is an automatic joint referral of a fraud case at the beginning. So you have cross-referenced assistants who were on the civil side who were working on the criminal side, and oftentimes the criminal case goes away when a civil settlement seems likely, and that begs the question of whether the criminal case is being used as leverage to gain civil settlements. The Justice Department is aware of this. Companies and individuals have made allegations. It's unethical conduct to do it, but it certainly happens. And this is an area that Rosenstein is sensitive to. It's something that you'll read about in the U.S. Attorney's Manual, that at least there'll be a warning not to do it, and that criminal cases should be pursued on their merit. But in terms of cooperation, once a decision is made, I don't see any difference between the two.
So I just to jump in for 2 seconds here. My sort of perspective was when I was a prosecutor and the Yates Memo came down, and I was still at the U.S. Attorney's Office when it came down, I sort of looked at it and said, what, we weren't trying to prosecute people, individuals to begin with? No, you went where the evidence took you. You went where you had proof beyond a reasonable doubt, which is such a high standard. Whereas what we're seeing emerge in some of these civil cases, as I think we'll get to in the rest of the presentation, is now individuals, whether it's individual doctors, individual within the corporate structure, are being held accountable by the Department of Justice in order for a settlement to occur to resolve a false claims act.
Well, every version, I don't want to belabor this, every version of this memo has made it clear that it doesn't represent a change in policy. I was once the head of the civil division, and I can assure you that we targeted individuals 20 years ago as they do today. There certainly are and were pockets of the department in various U.S. attorneys' offices in the hinterlands that were less than assiduous in pursuing individuals, oftentimes because they knew these people. They were in smaller districts. That certainly has changed.
So I think that it would be helpful to our audience to go down this road that we're talking about right now and take just a little bit of a deeper dive into new directions and fraud enforcement that's occurring under the Sessions Department of Justice. And we're going to look at both some civil areas and some criminal areas, of areas that we really see are emerging areas in terms of focus by the Department of Justice. And so I'm going to turn it over to Erica.
Thank you, Melissa. So we're about 9 months into a DOJ run by Attorney General Jeff Sessions, and we have not seen any sign of slowing down in terms of healthcare fraud activities, perhaps a shift in priorities, but no slowness because, of course, never fear, fighting healthcare fraud is lucrative for the federal government and will probably continue as to be that way. And you can see some of the data on the slide here. Just last year, $2.6 billion in federal recoveries just related to healthcare False Claims Act actions. That's an enormous amount of money, and I think that.
Yeah, let me say about that enormous amount of money, keep your eye on the ball out in the world, because that enormous amount of money is only recovered in a handful of cases. The department declines 80% of the Quiton filings. That's always been the case since 1986 when the False Claims Act was amended. In those part of the 80% that relators continue with, a relatively small percentage of the total recoveries are achieved. In the 20% that the Justice Department pursues, often in conjunction with relators, the lion's share of the money recovered comes in a handful of cases from the largest companies, pharmaceutical manufacturers, hospital systems, things along those lines. That's not to say that a $20 million settlement doesn't have great impact on a smaller organization, but the $100 million settlements and occasionally even a $1 billion settlement, which we've had on a few occasions, shouldn't create a false picture of what the government is doing, except that a lot of this represents wealth transfer. It doesn't represent classic fraud, and you'll see as the False Claims Act has been amended periodically, the bar has been lowered and lowered and lowered so that it's harder and harder to defend these cases. And the intimidatory value of them creates lots of settlements.
I completely agree. So you can also see that there's been a rise in the Medicaid Fraud Control Unit, the MIFCU actions, meaning that not just on the federal level, but the state level as well, we're really not predicting any slowdown in targeting healthcare providers and suppliers. So one of the biggest news items in healthcare fraud to come out of the session's DOJ is the July 2017 healthcare fraud takedown. They announced charges for over 400 people, valuing it at over $1.3 billion in healthcare fraud. I mean, this is enormous. All sorts of different providers are involved. We have physicians, we have nurses, pharmacists, individuals who are engaged in a lot of opioid-related fraud. You'll see opioids as a theme as we go on. We'll touch on it another couple of times throughout this presentation.
So one of the interesting things about this healthcare fraud takedown was for the first time they included HHS OIG exclusion notices as part of their overall numbers. And I was just speaking with an agent from the OIG who was indicated, I said, well, what were those notices for? They sort of gave a generic number saying, well, we have these people and they were given exclusion notices without any kind of deep dive. I've gone through all of their records trying to find an answer, and even the agent wouldn't tell me what these exclusion notices were. Were they opioid related? Were they mandatory exclusions? Were they permissive exclusions? There's a lot of nuances in this area, and so I thought that was sort of interesting.
As we look at these cases, though, especially if you're sitting in a corporation, this category of cases doesn't apply to you. These aren't billing disputes. These are classic fraud cases, services not being provided, services intentionally being misbilled, intentional coding violations. And these are all criminal. These are going to be criminal cases. These aren't going to produce recoveries of $1.3 billion. They're probably not going to produce recoveries of very much at all. But what they're going to produce are jail sentences for the people involved or exclusions from the federal program.
Right. Following up on what Stuart just said, one of the specific examples that the DOJ gave in its press release is that an example of 5 physicians in Michigan who were allegedly engaged in illegal kickbacks and billing for medically unnecessary services, including joint injections, drug screening, and home health services. Providing medically unnecessary services is a criminal category of its own, not a standard corporate investigation. So looking forward, we can take some indication of new enforcement directions from the OIG work plan update. As of June of this year, the OIG is now releasing monthly updates to its work plan, which is extremely helpful to us, really helps us gain insight into the new administration's priorities. And I've listed a few areas that have come out specifically since June 2017. Telehealth services, which we'll talk about a little bit more in depth in a few minutes. They're looking specifically at sites of service. Is the beneficiary at an appropriate site of service to actually be billing for telehealth services? Opioids, again, opioid treatment, they're looking into whether state agencies complied with federal and state requirements for Medicaid reimbursement for opioid treatment programs. We're looking at home health and hospice. Talk about hospice again in a few minutes. And one new, as of this past month, October 2017, is Medicare payments for bariatric surgery. According to OIG CERT studies, there is a significant risk for insufficient documentation as to whether the person receiving bariatric surgery fits all of the requirements, including BMI, comorbidities, and whether they have tried other treatment options prior to bariatric surgery. So that will be a priority for the OIG in the coming year. So I'd like to go a little further in depth on a couple of areas in which we've been seeing some significant activity. The first is telemedicine and telehealth. As it becomes more and more prevalent and states are adapting their individual regulatory schemes, the federal enforcement authorities are really targeting telemedicine practitioners, including pharmacies and nurses and marketing companies as well.
I think we're approaching a time when a majority of psychiatric services are going to be administered via telehealth. And that's particularly relevant if you're in this field to those of you who are dealing with Medicaid patients. I mean, the Medicaid needs among Medicaid subscribers, which under Obamacare saw huge growth in participation, burdening the states. Well, there's a need for psychiatric services. Psychiatric providers tend not to be available to the urban poor or people who live in rural areas. Their services are expensive to provide. Telehealth offers an innovative, less expensive way of providing the services. But as they're expanding, it's an area that could be subject to great fraud, and the government knows this. And so if indeed you're getting into that as part of a telehealth operation, it's something you should keep in mind in terms of your compliance programs.
I definitely agree. I prosecuted several cases involving telehealth services and the compounding that Erica, prescription drug compounding schemes that Erica's about to discuss. And I think that this is an area that we're likely to see increasing fraud in, both civil and criminally. Certainly, the TRICARE provides a lot of those kind of services. We've got service people having a lot of problems with the VA hospitals, and this is a really ripe area for ability to help people. But at the same time, there's just area for tremendous fraud because people think that telemedicine means just sitting at home in front of your computer or on the phone in your pajamas talking to someone, or from a provider perspective, just picking up the phone and consulting someone you've never met over the phone and giving them medical advice. And that's the exact opposite. There's very strict regulations, and we give webinars on this all the time on our telehealth medicine advisory side, that you need a certain pixel monitor, and you need to have a certain provision that you can't be in your house if you're a doctor. It varies by provider to provider as to what the requirements are, and it's quite complex.
Thanks, Melissa. So what we have seen recently, and what I'll be talking about in a minute, is the unnecessary prescription of compounded drugs. That's where we have been seeing a lot of the specifically criminal enforcement with respect to telemedicine providers. So compounding, in case you're not familiar with it, compounded drugs are drugs that need to be taken in via an alternate route. Say you need a pain medication but can't swallow a pill. A pharmacist may take out the individual components and compound it into a topical cream for you. Those compounded drugs, as they're called, are reimbursed based on their individual components. So a single tube of a topical pain medication can be reimbursed for, say, up to $50,000. So it's an enormously lucrative drug. So what we have been seeing, the particular scheme, is that there are telemedicine marketers who reach out to individual beneficiaries to say, we think you would benefit from this drug, or we'd like you to engage in this study for a certain type of topical drug. Let's go see, how about you see this doctor, a particular physician. The physician prescribes the, say, topical pain medication to the beneficiary, sends it to a pharmacy who is also involved in the scheme. Pharmacy receives the $50,000 per tube, pays a fee back to the marketers, who then pay kickbacks to both the beneficiaries sometimes and the telemedicine physician. So there's a lot of money coming in and a lot of money being kicked back to both beneficiaries and physicians and the marketers themselves. So we've been seeing this a lot in the Middle and Southern District of Florida, civil settlements, and we've been seeing some criminal prosecutions as well, Middle District and Southern District of Florida, Texas, and New Jersey. You can see from this slide that there are enormous amounts of money being poured into these compounded topical drugs. Part D spending between 2006 and 2015 grew 3,400%. That's enormous amount of money.
And I mean, the last line there is sort of a look into the future. We've seen cases involving private auto insurance compensation as being involved in these prescription drug compounding schemes. And there's been a huge case in the District of New Jersey involving state workers where there's been fireman after fireman who's been prosecuted. So there's definitely a lot of continuing both civil and criminal liability within this area, and it goes back to the importance of compliance internally to make sure that all of the appropriate regulations and laws, and each state varies in terms of their laws on this, how things are being complied with.
So I think it's also important to note here that in these schemes, the OIG and DOJ legwork is really done through spotting these schemes through data analytics. They're less reliant on individual whistleblowers. They are looking for things like physicians writing the exact same prescription for multiple family members, or physicians prescribing outside of their specialties. So, for example, gastrointestinal physicians prescribing topical pain medications. They're able to spot this just through the billing data that comes through their system.
CMS is doing roughly the same thing with respect to a number of codes and establishing national norms, error rates that are used to inform litigation and to guide companies.
We'll see the same thing in a new initiative under the Sessions DOJ with respect to opioid fraud and abuse, using data analytics to try to combat prescriptions that should not be given. So just to give you an idea of what these telemedicine fraud investigations look like, this is a criminal case that came out of the Middle District of Florida, and the important thing to look at here, both the first and last bullets, we have 7 defendants, individuals, physicians, physician assistants, pharmacists, who were all entered into plea agreements or were otherwise given jail sentences at the end. The last bullet is really important. Each one of those defendants is liable for repayment of restitution up to $6 million per defendant and jail terms up to 5 years. So again, looking at individual criminal prosecutions in action. The next one I want to focus on is unnecessary hospice care services, a very recent settlement of $75 million, Fetus Hospice Services, just last week actually, to resolve allegations that Fetus submitted claims for hospice services for patients who are not terminally ill. The Medicare's hospice benefit is only available to patients who elect palliative treatment for a terminal illness and have a life expectancy of 6 months or less. Patients who elect the hospice benefit therefore forego any of their right to curative care, and we see that this hospice corporation was providing services to those who were not terminally ill at that point in time. And this seems to be, according to DOJ, the largest ever False Claims Act recovery for a hospice services provider.
Well, and Erica, I think it ties back to what you were talking about before in terms of the OIG work plan, which does give us a window into priorities by the Department of Health and Human Services, Office of the Inspector General, who has made it clear that hospice and home health care are front and center on their radar screen, up there at the very top along with the opioid problem. So this is an excellent example of the OIG work plan in action.
Exactly, and we're seeing a lot more of these, just a couple over the last 3 or 4 months. Hospice and home health is a target. And the next is that we see emerging is Medicare secondary payer.
Maybe we go back for just 1 second, because when you saw it said focus on unnecessary hospice care. Well, that's a discrete field, but the department itself has been looking at cases in managed care and elsewhere where they're alleging that unnecessary services have been provided. These are often unusually defensible cases. Your chances of winning a case like this are better than in a number of other areas, because necessity is often a question of debate and judgment. And so you need to distinguish in analyzing these, both as a law enforcer and as an entity providing services, between cases where there's a mens rea, an unlawful intent, and other places where legitimately a physician or an entity is making coding decisions and treatment decisions based on judgment. You need to be careful in this area, But I just wanted to note that companies are winning cases like this. This is the most difficult area to prosecute if you're the government.
Well, and I think this issue of medical necessity, we're going to have some more slides on it later on in the presentation, is really front and center because it's so difficult for the government to prove that something was not medically necessary. And you really do sort of enter a swamp from the prosecution perspective of medical necessity, of dueling experts. And there's some case law out there where courts have said enough is enough. Is dueling experts, does that mean that something's not medically necessary at this point? And I think this is really an area of the law that we're going to see fleshed out much more in the next few years.
Yeah, I mean, keep in mind the burden of proof. In a criminal case, they're next to impossible because the criminal standard is beyond a reasonable doubt. Well, it's not hard to inject reasonable doubt into a case like this. Civil standard is preponderance, but as Melissa says, courts are increasingly willing to take that one up. So that if I'm talking to a legitimate company, not a fly-by-night operation, which I wouldn't be talking to in any event, a company that believes that it's acting appropriately and is willing to stand behind the array of judgments that a statistical sample has brought to the fore, my advice is fight, don't settle. But again, I just note these things, that this is an unusual category of cases. It's where the government is pushing the envelope.
I think I end up more talking than fly-by-nights. No. Just kidding. Okay, so Erica, we're going to turn it back over to you in terms of this amazingly important area that we really see as being coming more to the forefront in the next few years, the Medicare secondary payer.
Right, so and if you're not familiar with the MSP statute, it really comes down to the fact that if an individual has multiple sources of insurance, if a Medicare beneficiary has multiple sources of insurance, Medicare pays second in many circumstances. In limited circumstances, it pays first. But it is the provider's burden to determine whether a Medicare beneficiary has the additional insurance and to bill that additional insurance first. And you can see that there are at least 2 cases, recent cases, where we don't have a conclusion yet, whether this is a settlement, whether it goes to trial, but we have seen them pass the motion to dismiss phase. So the courts are allowing this theory to go through under the False Claims Act.
I would note that the reason that you're going to see more of these cases is demographic. Not only is the population increasingly aging, but people are working longer. So there's much more chance to have a primary payer, not Medicare.
Correct. So I would, for all providers out there, I would pay attention to really ensuring that the beneficiaries that come through your doors either don't have additional insurance, or if they do, to ensure that the other insurance is the primary billed insurance.
So the next couple of slides, we focus in on a couple of civil cases where, in my opinion, we really see the Yates Memo in action. The first is sort of an area that has not been subject to false claims litigation prior to this particular settlement, which happened at the end of May in the District of Vermont, which is not known to be a hotbed of False Claims Act settlements. And in this particular case, the Department of Justice settled with a clinical health record, an electronic health record vendor, eClinicalWorks, for $155 million. The settlements resolved allegations the company and its 3 founders misrepresented the company's electronic health record software capabilities, and it's actually quite complex in reading the numerous things that the company is alleged to have done in the settlement agreement. But simply put, if you tear away all of the details behind all of that, the 3 founders of eClinicalWorks, its CEO, its COO, and its CMO, were held jointly and severally liable for the enormous settlement of $155 million. But notably, a developer and 2 project managers were also subject to the settlement, one for $50,000 and 2 for $15,000. So you really see them attempting to get to the programmer who programmed this particular program so that it would only look at 6 codes that the company knew would be audited and didn't look at the remainder of the codes. So while health information technology vendors generally have stayed out of the spotlight in False Claims Act litigation, the nature and the amount of the settlement is sure to draw further investigations in the sector. Additionally, what we're seeing in some cases is that we're getting inquiries from the government in terms of how their EHR programs are being applied in billing issues. Are things being set to automatically add on modifiers, for example? Those are all questions that are going to increasingly come down on the pike, sort of this intersection between billing and the use of electronic health records. And I think we're going to see more cases exploring this particular area. There was a whole kickback component to this case, which was just sort of a minor issue. It really was focused on the details of how this particular software was constructed and the way in which it caused the people who use their platform to file false claims. So they were not filing the false claims. They caused other individuals to file the false claims. And that's sort of one of the unique aspects of this particular settlement. The next particular slide has to do with Norman Regional Health System. Again, this is an illustrious example of a case in which Norman Regional Health System settled with the Western District of Oklahoma and the Department of Justice for an improper billing scheme. It was alleged where the radiologists were not in the room during the time that the radiology that the treatment was being given to the individual Medicare patients. The Medicare regs required that if the physician was not in the room, it could not be billed to Medicare. But interestingly enough, the former hospital administrator and 6 separate physicians were also required to pay part of the $1.6 million settlement in the course of that settlement. So those are some examples of how we're seeing the Yates Memo being applied within the civil arena. Next, we're going to move on to some other areas where we have False Claims Act updates, such as cybersecurity and life in the post-Escobar world. We're going to look at some of these medical necessity issues, and we're going to look at opioid enforcement. And we're going to move through this quickly because we're running through our hour.
That's an instruction to me. Cybersecurity and data privacy is not really the province of the Department of Justice. It's much more the Federal Trade Commission and Securities and Exchange Commission. But I put this slide in here for a particular reason, because I want you to know about the Spokio case. It's one of the more important cases that the Supreme Court has decided in the last few years. And it's an Article 3 case. It says that standing requires actual injury in fact, not speculative injury. It comes up, Spokio was not a data security case, but it comes up in virtually every data breach case. You will be dealing with the Department of Health and Human Services if you're in the healthcare field and you have a data breach. And one of the things that you'll find is, notwithstanding all the TV commercials and all the attention that has been paid to individual identity theft, it's a non-factor. That's not what these cases are about. These are big data plays. They involve banking. They involve attempts by state-sponsored terrorists to do things like hack elections. And courts increasingly are recognizing what the Supreme Court has said, which is you can come to me if you have a real case, one where there's injury in fact that's proximately caused by whatever it is that you're complaining about. In data cases, that's often not the case, and consistent with the Supreme Court narrowing the opening of the courthouse door in cases like Iqbal and Twombly and Italian colors with respect to arbitration, you should keep this in mind. So no to the Spokio case. In terms of what the Justice Department actually does, the case that you need to know about is Escobar, Universal Health Services, Inc. against United States ex-rel Escobar. This is a case that had 2 forks to it. In one, the government got a win. The Supreme Court recognized the implied false certification theory of liability. Nothing greatly novel there because courts generally had been recognizing it. There are only a few outliers, but it means that someone is at least potentially liable under the False Claims Act if you are certifying that you've complied with all conditions of payment, including laws and regulations. But the other part of Escobar is the one that I want you to think about, and that is that for a submitter of claims, a contractor to be held liable under the False Claims Act, the government must meet a demanding test of materiality. What does that mean? In simplest terms, is if the government knew about the thing that is being complained of and continued to pay the bill how could something be material as part of a fraud? Why do I signal this? Because, as I said earlier, the bar has really really lowered on the ability of a relator or the government to prove a False Claims Act violation. Things that used to be defenses involving original source, involving the dismissibility of cases, have, with a series of amendments over the years, including part of the Affordable Care Act, really made it much easier to pursue these things. But the holdout issue is materiality. So you really need to focus on it. A good case, the courts have been all over the place on this, but a really good case to look at, which was decided only a few weeks ago in an influential circuit, the Fifth, with an opinion written by an influential federal judge, Pat Higginbotham, is the Trinity Industries case. That involved, as the court narrated, a really critical issue in dispute about the nature of guardrails and whether a relator who alleged documentable injuries as a result of guardrail failure could bring an implied false certification case. And the Fifth Circuit held that he could not, because while this was an important issue, the government knew about it. It was something where there was a great deal of back and forth, where there wasn't a clear answer, but where the benefits of these guardrails seemed to outweigh the detriment, that more lives were being saved than lost. It's a strong case of no materiality, and the court ultimately held that. So I want you to know about Escobar as a general rule, because it will come up time and time again, and the Spokio case, because it will be relevant to other areas. So Article 3 lives, and there at least are some available defenses if you choose to litigate a False Claims Act case. Melissa?
So the next couple of slides have to do with clinical decision-making as a basis for False Claims Act indictments. We touched on this. I will leave that to you all to read the slides, which have the standard out there. On slide 31, we have a couple of the cases that have been litigated in this front in terms of from a criminal perspective, where the federal government has prosecuted a series of cases involving cases where physicians administered tests or treatments that were later on deemed medically unnecessary. There's a whole range of cases nationwide. There's more cases than are listed here where doctors were inserting stents and involves the appropriateness, of cardiology procedures. One of our partners, Rich Westerlane, defended one of these cases at trial. And what we're seeing is, combined with the sophistication of what Eric was talking about in terms of the claims data and the use of data mining, it's easier than ever for government prosecutors to target hospitals and providers reporting a higher utilization of certain procedures. And in that particular area, the issue of medical necessity will always be front and center. And it's tough to litigate because it involves a lot of uncertainty, and it involves expert testimony and for engaging an expert and making sure you engage them properly and all of those kinds of things. The next couple of slides have to do with the opioid crisis and the federal government's increasing crackdown through the Department of Justice and through HHS. We are going to skip through the couple of slides. We are seeing False Claims Act litigation within this space, and that's on slide 33. For example, Clean Slate Addiction Treatment Center settled allegations of unlicensed prescribing and improper billing. Every single day, you open the newspaper and you are seeing people charged either criminally or civilly for being involved in pill mills, and still yet the opiate problem is getting worse.
Well, you keep in mind that a lot of this has been created by virtue of government policies which have moved towards stimulating opioid prescription. Why is this important to you? Well, you're not going to be involved. The people listening on this call are not going to be involved in pill mills or street operations with drugs. But you are going to be in systems that are prescribing opioids, that involve physicians making decisions in this area. Donald Trump is not known as a detail person with good cause, but yet opioids is something that he knows about and has signaled is a priority. And certainly he's found plenty of support for that on Capitol Hill. So in your systems, whether they're managed care systems, hospitals, whatever, opioids is in the crosshairs.
I definitely agree with that. And the most high-profile criminal prosecution on this front involves the Babbage indictment in the District of Massachusetts, where there was just a superseding indictment that was brought 2 weeks ago, adding an additional former executive who are accused of bribing doctors to prescribe a pain version of fentanyl, which is an opioid called Subsys. And that has definitely been in the news and is front and center. There have been numerous other state false claims actions filed against the manufacturer. There was even a local county that has brought a criminal prosecution in the local county of Tennessee. So we're really seeing these kinds of cases being parallel investigations on multiple fronts. Similarly, a similar product, Abistral, we saw a False Claims Act settlement just 2 months ago by the District of New Jersey in the Galena Biopharma case. And that case involved 2 physicians who were convicted of running a pill mill criminally in the Southern District of Alabama, and then the parallel civil investigation was settled in the District of New Jersey in September. Other recent enforcement examples, the Alpha Bay, that was just a revolutionary case brought by the Department of Justice. They shut down this dark website that sold opioids, drugs, firearms, cybercrime malware, probably my stolen credit card number from last week, and all sorts of other things went through that site, and we're really connected into this issue of opioids, and is a new way of the federal government going after large quantities of opioids being distributed around the country.
So the DOJ has also announced that it is forming an opioid fraud and abuse detection unit. Again, like many other initiatives, this is rooted in data mining, so not dependent on any individual whistleblowers to help combat opioid fraud and abuse. They're targeting really the pill mill schemes, but also pharmacies and potentially individual physicians as well that unlawfully dispense or divert prescription opioids for abuse. It is a target for the Trump administration.
So our next slide and our last area, which we're going to get in right under the wire because we want to save some time if anybody has a question for us, is just will there be easing of enforcement of the Foreign Corrupt Practices Act? And there should be a question mark on that.
Yeah, and the answer is no. And let me just say something about it, though, because the number of cases are being reduced even though there's no easing in enforcement. To summarize, the key elements of the Foreign Corrupt Practices Act violation are well known. It involves a U.S. person or company offering corruptly to pay or give something of value to a, quote, foreign official, unquote, for the purpose of influencing an official act to gain or hold on to or direct business. Why do we mention this with particular reference in healthcare? Because increasingly, U.S. healthcare entities, both manufacturers, but researchers, universities, a host of healthcare providers of goods and services are looking to expand businesses in foreign countries. Oftentimes, they're the so-called red flag countries that have growing economies, like, for example, Brazil. But the particular problem that a healthcare company has is that frequently they're dealing with state-run healthcare systems. That's true all over Europe. The definition of a foreign official is very, very broad. The Justice Department almost never has lost a case where that is the definition. And so you need to keep in mind the fact, if you're in a country like China, where increasingly we're doing business, that virtually everybody is an employee of the state and arguably is a foreign official. Anybody who's buying goods for a healthcare facility in China is most likely, virtually certainly, a foreign official. I noted that cases are going down, not up, for two reasons. One, there's a voluntary compliance program that the department is instituted and is working out well. And keep in mind, the Foreign Corrupt Practices Act for public companies is jointly enforced with the SEC. But in addition, companies are paying greater attention to what can be vast liability under the Act, and compliance programs have become very good. And there's a lot of vetting of business deals and individuals and freight forwarders and the like of that. So to keep this in mind, it's still going to be a hot area of enforcement. There is a voluntary compliance route that can be increasingly be followed and is being followed, and your compliance program should be directed at identifying, preventing, eliminating FCPA issues.
Well, so what we saw is that there was the most vigorous year of FCPA settlements ever in 2016 at the end of the Obama administration, and then there's been a really small number this year. But yeah, Stuart, I think both of our sources within the Department of Justice are telling us that their cases are in the works. The FCPA tracker, for example, says that there's at least 80 known investigations going on in terms of public companies right now in the United States that are FCPA related. That's in addition to the SEC investigations, which you mentioned are under the Books and Records provision. And the SEC FCPA unit just announced a new head of their unit at the SEC last week, whose job is to level the playing field for U.S. companies. That's his stated mission. So we're going to see that. We're also going to see, in terms of the synergy between FCPA and healthcare, there was a major new announcement by the acting criminal fraud chief, Sandra Moser, this summer that there's going to be coordination between the DOJ's healthcare fraud corporate strike force and FCPA prosecutors to do not only international-based cases, but there's also going to be domestic healthcare cases that are going to draw upon those strengths of those two data-driven and meticulous units who are used to putting together very, very large data-heavy numbers and combined forces. So we're going to see that in the future. So moving forward to our next slide here, these are just some thoughts that echo our theme about compliance, compliance, compliance. From acting criminal fraud chief Sandra Moser, that she's urging people to invest in compliance, and that's what we're hearing in terms of the white-collar side of the house. Stuart, any last thoughts?
My last thought is that I hope we've been informative, instructive. We can be reached by email if there are follow-up questions, and I, for one, thank everybody for listening. I hope this has been a profitable session.
Definitely. Thank you very much, Erica.
Thank you, everyone. This concludes today's webinar, and approximately 2 to 3 business days following this webinar, we will communicate the availability of the webinar recording and access to the PowerPoint materials. Thank you for attending.